Assalamualaikum, I'm Luqman from Group 1. So, as you all know, there are three different eras for the hierarchy of superior courts in Malaysia. And for the first era, it consists of Privy Council, Federal Court and High Courts only. And for the second era, it consists of High Courts, Supreme Courts and High Courts only. And for the third era, which is current era, it consists of Federal Court, Court of Appeal and also High Courts only. So for the issues for Privy Council, whether it is bound by its own decision, the Privy Council was the highest tribunal from Commonwealth countries. It was the highest tribunal of appeal for Malaysia until 31st December 1984 before it was abolished and has been replaced by the Supreme Court as the highest appellate court in Malaysia. After 31st December 1984, only decision made by the Privy Council, which was an appeal from Malaysia, are binding on Malaysian courts. Because at the time the Privy Council decided the case, it acted as the apex court of Malaysia. However, the Privy Council decision on appeal from other Commonwealth countries after the date may be persuasive precedent, and Malaysian courts are not bound to follow the decisions. The next issue is whether the Court of Appeal is bound to follow the decision from the Federal Court. And the answer is yes. The Court of Appeal is bound to follow the decision made by the Federal Court. Because according to its vertical operations, and by referring to the case of Cooperative Central Bank Ltd against Fayan Development Sudan Berhad, this case highlights the importance of following the decision of a Supreme Court, which is the Federal Court. And then the Court of Appeal may also depart from the decision made by the Federal Court if there is evidence that the decision given by the Federal Court is per incuriam. And next, for the Court of Appeal, it also has its own predecessor, which is the Supreme Court, particularly for personal injury and dependency claim. Furthermore, the Court of Appeal is bound by their own decisions except for three situations, whereby according to Dalit Baguan Singh against PP, for the first exception, a decision of the Court of Appeal given per incuriam need not to be followed, and then if there is conflict with its own previous decisions, the Court of Appeal may choose which decision to follow. And number three, Court of Appeal ought not to follow its previous decision if overruled by the Federal Court. Whether the High Court is bound to follow its own decision. So the answer is no. The High Court is not bound to follow its own previous decision in both criminal and civil matters. And in one decided cases, which is Sundralingam against Ramanathan Chetya, this case talk about the Federal Court. This case talk about the Federal Court held that another High Court judge was not bound by one High Court judge. In practice, Malaysian High Court judges have acted on the premise that one High Court judge is not bound by a decision, and this because the decision is made by one judge only.
Decisis is the principle of following a precedent educated by a superior court in the past. So the Privy Council during the pre-1985 era was not bound by its own past decision. The abolishment of Privy Council after the 1st January 1985 enforced the doctrine of Decisis of Malaysian appeal cases in Malaysian courts. However, the Supreme Court has authority to depart from the processive precedent. Secondly, the Federal Court is not bound by its past decision in criminal cases as opposed to being bound by its civil adjudication. So the Central Security Holdings Berhad and Harun bin Muhammad Zaid and AFIQ against private prosecutor. So the Supreme Court in the second era is not bound by the Federal Court decision in the first era in the Government of Malaysia, UAM and Lim Kit Siang, whereby the majority decision departed from the Federal Court decision. Thirdly, the High Court of Malaya and Borneo are not bound by its past decision on the same level. In the second era, it is bound by the decision educated by the Privy Council from the past, so long as it is aligned with the decision of the Supreme Court. However, the High Court is not bound by the prior Federal Court decision. The Supreme Court is bound by its own previous decision, as prevailed in Lorraine Osman against Attorney General. Post-1995, the Federal Court is bound by judicial precedent in the Supreme Court during the second era. In the case of Lee Gi Chong, it is mentioned that the Federal Court is the successor of the Supreme Court. bound by the decision of the Supreme Court. In Encouragement Sundar Berhad and Iramatin and another, decision of Supreme Court binds the Federal Court unless it is reserved by the Federal Court. However, the Federal Court may depart from the precedent in civil cases. In Malaysian National Insurance, the Federal Court overruled the decision of the Supreme Court because it was wrongly decided. Conversely, the criminal judgment made by the Supreme Court in the past are strictly binding upon them. In Tan Boon Kiong, the Federal Court unanimously had itself bound by the Supreme Court's decision. The Court of Appeal and the High Courts are also bound by the doctrine of stare decisis from the past decision made by the Supreme Court. The Court of Appeal is bound by its decision in civil cases and not criminal cases. It is bound by its past decision, but may depart from them if the precedent is wrong, unclear, unjust, or obsolete, as mentioned in Dalit Bhagwan Singh against public prosecutor. Furthermore, the Federal Court is not bound by the decision of the Privy Council from the first nor the second era. In Aru Pergasan Anak Lelaki Sandaraju against public prosecutor, the court may depart from the principle laid down by the Privy Council in How to Tau against public prosecutor on burden of proof. Similarly, in Majlis Pembayaran Pulau Pinang and Syarikat Bekerjasama, the Federal Court is not bound by Privy Council decision, including those delivered on appeal from Malaysia. However, the Court of Appeal and High Court is bound by its decision. Secondly, the Court of Appeal is generally bound by its own past decision unless it is a decision made per incurium, a decision that it is conflicting between Court of Appeal decision or a decision that is overruled by the Federal Court. Thirdly, the High Court in the Third Era are not bound by its decision among